there, and welcome to LawSplained Simply, a channel designed for you to empower you and to educate you when making legal decisions. My name is Ruzbe Hosseini. I'm a partner at Cambridge LLP in Toronto, Ontario, Canada. And I and my firm assist clients in making litigation decisions on a day-to-day basis. This is episode 5. And in today's episode, we will be talking about causes of action. And if you recall in episode 2, we discussed pleadings, specifically statements of claim. And so today we're going to delve a little bit into what you need to write when you're making a claim in a statement of claim, when you're putting pen to paper in a statement of claim. So let's begin. So what is a cause of action? A cause of action is a legal basis for suing somebody. So for example, there's a cause of action of negligence. There's a cause of action for breach of contract. There's a cause of action for defamation. And then what's not on the list, for example, fraud. And there are many other causes of action that you could look to when you're seeking relief against a defendant. And each cause of action has defined elements. And these elements are individual components that together make up the cause of action. You can think of this as a checklist. The things that you need to say or write in order for the cause of action to be complete. And each element of each cause of action must be present in your statement of claim. And if it's not, if there's an element missing, that cause of action can fail. So what do I mean by that? Well, let's start with a very simple example. And one example that you may find yourself in a dispute regarding, which is a breach of contract. Okay, so let's say you lend somebody money and they don't pay you back. Okay, the lending of money is a contract because they promise to pay you back. And if they don't pay you back and you have to sue them, you need to know what the elements of the cause of action of breach of contract are. So let's go through that. There are 3 elements to a breach of contract cause of action. And they are a contract, the breach of that contract, and damages. Okay? So all 3 of those elements have to be in the statement of claim in order for you to be successful. Let's have an example. Okay? You see my 3 elements, 1, 2, and 3. A contract, breach of contract, and damages. Let's say you lend John $1,000 and John signs a promissory note to pay you by, September 1st. September 1st comes and goes, and despite having signed that promissory note, John doesn't pay you back that $1,000. There's the breach, right? Because the term of the contract, the term of that promissory note was that he would pay you back by September 1st, and he didn't. And as a result of that breach, you have damages. You're out $1,000. So if you prepare a statement of claim with those 3 elements, you've made out a proper cause of action in breach of contract. Here's another potentially common example and a simple one. The cause of action of detinue, which is basically a fancy word for somebody took something that wasn't theirs and they're not giving it back. Okay? There are 3 elements to a cause of action of detinue. The first is right to immediate possession of an item. 2, a proper demand for the return of that item, and the refusal to return. So let's go through that example. Let's take a fictional individual named Julie. She takes a ring from you that's not hers, that belongs to you, and she's not entitled to have that ring. You didn't give it to her to wear, for example. Okay? Well, the first element is right to possession. You have a right to possess that ring, and she has it. That's 1. Okay? 2, you make a demand. You send her an email or a letter and you say, Julie, you took the ring, give it back, please. And 3, she doesn't. She doesn't return the ring. If you sue her for a return of the ring and you plead right to possession, demand for return, and the refusal of Julie to return the ring, you've pleaded all the requisite elements for the cause of action of detinue. So, some key points, some key takeaways. 1, the pleadings, in this case a statement of claim, must allege all the facts supporting each cause of action. And you saw in our 2 examples, one with John and the other with Julie, we set out the facts of each cause of action. If you don't plead properly, for example, if you don't plead all the elements of a cause of action, you may be subject to a motion to strike your pleadings for not having pleaded properly. Even if you plead properly, that doesn't mean you've proven your case. Okay? The pleading stage is simply the stage where you make your complaint. Ultimately, a trial will determine whether or not the evidence supports the material facts that you've pleaded in each element of each cause of action. And the reason why lawyers write this way is because it provides clarity. Lawyers are trained to think in a certain way and to think in a way that judges and the courts think. And by pleading only the elements of each cause of action and then setting out to prove those elements at trial, it provides structure to the legal arguments, and those submissions that the lawyers make on those elements allow the judges or the court to make reasoned decisions. I hope that's helpful. And of course, in future episodes, we're going to delve deeper into other causes of action. For example, fraud, defamation, et cetera, and to help give you guidance on other causes of action that you may have against individuals. So thank you very much for joining us on this latest episode of LawSplained Simply. Don't forget to join us on new episodes that come out once a month on other litigation topics, which may include other topics related to causes of action. I look forward to seeing you in those episodes. Don't forget to like, subscribe, and comment, and we'll see you soon. Bye-bye.